Of course, as you're probably told in all of our presentations, we are not giving you legal advice today. I'm going to give you an overview of the law. If you have a specific question about something that's going on in your district, you should consult with your district's legal counsel. If we happen to be your legal counsel, please feel free to reach out to us after the presentation so we can have a confidential conversation about something specific. So let's get started. So I'm going to start with sources of authority. So the first page in your materials in your handout, I'm not going to spend a lot of time talking about it, but there's a comparison document between the IDEA and 504. And as I'm sure you probably know, the IDEA is quite a bit more complicated than 504. It takes a lot more to be in compliance. The regulations for 504 that apply to secondary schools are just about 4 pages long. That's it. The IDEA regs are several hundred, I want to say like 600 pages. So we're talking about something that's certainly far less regulated than the IDEA. And that first page gives you an at-a-glance comparison of the two laws for you to refer back to. So let's start with what the law says. 504 is part of the Rehabilitation Act of 1973. So by its name, you know the law is super old. It's been around almost as long as I've been alive, but not quite. It is interesting that there are so many questions about 504, though, because the law hasn't changed in all that time, and it's only one sentence long. So since we're going to spend the entire morning on the law, I'm going to read it to you. As we go through the presentation today, just remember, though, because this law went into effect in 1973, the vocabulary is dated. So anytime you see the word handicapped in the materials, just know that that's not because we're insensitive. It's because that's the term that's used in the original law or the original regulations. And we now use other terms, but we've got the historic language, in the materials for you because that's how it currently exists. So here is the relevant portion. No other qualified individual with handicaps in the United States shall, solely by reason of his or her handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So that's the basis of the law. That's 504. We can't deny someone participation in our educational programs or the benefit of our programs or subject people to discrimination because of their disability or on the basis of their disability. So it's an anti-discrimination law. It's a statute of access. If you receive federal funds, you have to make sure what you do is accessible to people with disabilities. And that is really the overarching principle that's going to guide every single decision that you make under Section 504. So in addition to the law, we also have regulations. The U.S. Department of Education promulgated the regulations, and the regs for 504 for K-12 schools, about 4 pages. If you add preschool and post-secondary, they're 12 pages. So we're not talking about a lot of text here. So you might ask, why are they so complicated? I mean, even for a lawyer, it's hard to imagine talking about 4 pages for 2.5 hours, but there is more authority than that. So every time the Americans with Disabilities Act, the ADA, is amended, there's what we call a conforming amendment. So every change to the ADA also applies to 504. And that's how we've gotten some of the newer interpretations of 504, even though nothing substantive in the law has actually changed. And the most recent amendments to the ADA were in 2008. So that's been a while too. But Congress made pretty significant and sweeping changes with those amendments back in 2008. And that, again, made those significant changes to 504. So I'm going to point that out as we go. I'll talk about those changes. But the major thrust of those changes was that Congress wanted to say the courts have been reading the ADA too narrowly. It was to broaden the scope, broaden the application of the ADA and then of 504. So it expanded the scope and then, of course, expanded the scope of 504. We also have guidance from the Office for Civil Rights, or OCR, and that's the office that enforces 504. If you've gone through a complaint in your district that was filed with OCR, then you probably know a little more than you want to about how that process works. But we do have guidance from OCR. And the way they issue that guidance is they put out these letters called Dear Colleague letters. And Dear Colleague letters provide significant guidance on how they're going to interpret and enforce the law. So those are authority that we need to pay attention to. Those letters are not law themselves, but it is a statement of how OCR is going to interpret and enforce the law. So it gives you an insight into their thought process and their thinking. So we'll talk about a couple of those letters as we go today too. All right, so I'm going to go back to the basic civics lesson. We start with 3 branches of government, right? So we have the legislative branch that creates the law, we have the judicial branch that interprets the law, and the executive branch that carries out the law. So laws come from Congress, right? And they're passed by the legislative branch. But sometimes the law itself that is passed by Congress says right in it that Congress is going to grant authority to the executive branch to promulgate rules to an agency of the government, and in this case, to the Department of Education. So even though the Department of Education is in the executive branch of government, their rules, because they're authorized by Congress, they become law. So those rules are how the law is going to be administered. Now, the Department of Education goes through a rulemaking process when they adopt rules. They have to give notice, and then they have a public comment period. They have hearings. They have to, jump through all those hoops before the regulations are adopted. And you may recall that's what the Department of Education did back in, it was the end of 2018 until the middle of 2020 when they were going through the Title IX regulation process. When the current Title IX regulations came out in May of 2020, they had been through all those procedural hoops. They had the notice of proposed rules and the comment period, and then it took a great deal of time for the Department of Education to sift through all those comments and discuss them, and they published an analysis of all those public comments when they proposed the rules. So that took a really long time. Dear colleague letters don't go through that process. So like I said, they're not law. They don't go through that formal process. And so sometimes they're rescinded with different administrations. So we get a little whiplash sometimes. And again, not to totally harp on Title IX, but that's certainly been hot button issues in the Title IX space is dear colleague letters have been rescinded. And we're getting this, back and forth with the administrations. So the dear colleague letters are important, but they're not law, they're not regulations. But we'll talk about the ones we're going to talk about today have been around forever. So those are your sources of legal authority. Okay, so where do we start? The very first substantive requirement under 504, applicable to pre-K to 12, is child find. And note that this obligation is not applicable to post-secondary institutions. So for anybody who has a career tech program that runs a post-secondary program, this piece of 504 does not apply to post-secondary programs. And that actually comes up sometimes. But for pre-K to 12, we've got a child find obligation. That's your first obligation, just like under the IDEA. There's a citation to the regulations in the materials. You'll see it 34 CFR 104.32. That's child find. Every time you see that 34 CFR in your materials, that's the citation in the regulations. CFR is the Code of Federal Regulations. 34 is the volume, and then the number at the end is the chapter and citation number, so that you'll be able to find it if you happen to want to peruse the actual text of the law. But the regulation says that you have to undertake to identify and locate every qualified handicapped person residing in your jurisdiction who is not receiving public education, and take appropriate steps to notify handicapped persons and their parents or guardians of your duty under this law. And then you're charged with conducting an evaluation of any child who, because of handicap, needs or is believed to need special education and related services. So that's your child find obligation under 504. And you will notice how closely that resembles the child find obligation under the IDEA. So you're required to conduct an evaluation when you have a student who is believed to need special education and related services. So you meet that child find obligation under 504 the same way you do under the IDEA. You publish a notice over the summer, and it says, if anyone knows of someone with special needs, please have them contact the Director of Student Services. Notices usually cite both the IDEA and 504 because you have an obligation under both, but you can satisfy it in the same way. So I'm going to spend a significant amount of time talking about the next section, which is what is an individual with a disability under 504. So there are 3 different ways that an individual falls within the protections of the Act, and they're on this slide. So the first one is the obvious one. It's an individual who has a physical or mental impairment that substantially limits a major life activity. And I'm going to unpack that in a minute, but that's the basic, the basic definition. So someone with an active disability, and that's what I'm going to spend most of our time talking about. But there are also other categories of individuals who are entitled to protections under 504 on the slide. It protects individuals who have a record of impairment. So maybe they don't have an active disability. That would mean somebody who's no longer disabled. So in their records, they have a record of being impaired. Maybe a preschooler who was identified but was exited when they reached school age. That person is protected from discrimination on the basis of their record of impairment. And then the last category is the individual who is regarded as having an impairment. So it could be an impairment that is minor or transitory, or an impairment that does not substantially limit a major life activity, but that is perceived as a disability. So those individuals, they're not going to be identified as individuals with a disability under 504. So they're not entitled to programming, but they're still entitled to the anti-discrimination protections under the Act, because remember, this is an anti-discrimination statute. So just know that the statute provides anti-discrimination protections to people in all three of those categories. All right, so is the impairment a substantial limitation of a major life activity? So we're gonna break that down like I said we would. There are really three concepts in the definitions. So one is the physical or mental impairment. The second one is the substantial limitation, and the third one is a major life activity. Now, before we get too far into what those three things mean, I'm going to talk briefly about a person with a temporary disability, like a broken leg or a broken arm. Are they someone with a physical or mental impairment that substantially limits a major life activity? Maybe, probably. But we have some guidance on this, and it comes from those 2008 ADA regulations. Temporary disabilities only count as a disability if the expected duration of the condition is 6 months or more. So typically, a routine broken leg or broken arm is going to heal within that 6 months. So even though they may have a physical impairment that substantially limits a major life activity, it's not going to qualify them as disabled under the ADA because it's expected to resolve within 6 months. And there's a case in your materials about this, but the takeaway is we don't treat it as a disabling condition if it's expected to last, 6 months or less. But you got to be watchful about these situations, because sometimes you think something is expected to last only 6 months and it continues on. Something becomes more complicated. We're seeing this come up a lot with students with concussions. A student gets a concussion, we think it's going to be brief, and then the next thing you know, 6 months later, and they're still having impacts from that concussion. So if you have a student with a concussion, you should be monitoring whether that impairment of a major life activity continues beyond the 6 months, even though it's temporary. It can still qualify under the ADA if that temporary condition is going to happen, long enough. And you have that continuing ongoing child find obligation. So if the condition that you thought was going to be temporary extends beyond the 6 months, they're exhibiting needs in the classroom, that are still ongoing after that, headaches, difficulty concentrating, that sort of thing that you would expect to see from a concussion. Just be aware that that temporary impairment may have just turned into an impairment that qualifies the student under 504. So substantial limitation, let's talk about that. I'm sure this won't come as a surprise, but the regulations don't give us a bright line definition of substantial limitation. You're going to find that might be the ongoing theme in all types of special education services, right? Because definitions, by their nature, these are all unique situations, and that's how we're supposed to look at them. So there aren't a lot of bright line tests. So what is a substantial limitation? I don't know. It depends. There's not really a legal answer, but I can give you an example. So if you have a student who presents with a gluten intolerance, the student does not have celiac, just an intolerance, and they don't do well when they're consuming gluten. We can agree that that's an impairment, but there are no issues with the child. There are no limitations in the educational setting. So the analysis is going to look different if you've got that same child, but they're missing instruction and they have routine absences because of that gluten intolerance. But here, there's no substantial limitation because the child is not being limited by the impairment. So again, just remember, it's a case-by-case analysis, and you have to look at the facts. You think about how that impairment is manifesting and then make a judgment. But we don't really have a definition. Now, we do have a definition of what a major life activity is. And this also comes from the 2008 regulations, and it was an expansion of what that was interpreted to mean before the 2008 regs. So there's a list in the handout on the top of page 4 But let me give you the caveat that anytime you see a list in our handout, it's not an exhaustive list. This is just supposed to be, this is pretty extensive, but it can't possibly cover everything because every case is different. But when you look at that list, you'll see that just about everything you do, caring for yourself, performing manual tasks, seeing, hearing, eating, sleeping, walking, those are all on that list of major life activity. And if you look to the right, you'll see the activities that are bold: learning, reading, thinking, concentrating, communicating. Those are the things that you're doing as educators in your building every day. So the things your students are doing every day, they're right there in the 2008 regulations. And those were added to the definition of major life activities at that time. So this is one of the areas of expansion. Other expansions that came with those 2008 regs are the operation of a major bodily function. And so that pulled in things like celiac disease or Crohn's disease, cancer, other long-term illnesses that affect the operation of a bodily function. All right. So, oh, I'm sorry, I am on the wrong slide. Okay, substantial limitation. It must be determined without regard to what we call mitigating measures. So this is another area that was expanded in 2008. You can't consider the student in what we call their mitigated state when you're trying to determine whether they have that substantial limitation. So in other words, if you've got a student with ADHD and that student is taking ADHD medication, and on the medication, they can concentrate and they're not wiggling in their seat and they can attend to their work and remain completely focused. When you evaluate them, if you say they're not substantially limited in a major life activity of thinking and concentrating, because that's not manifesting in the classroom, you're looking at the student in their mitigated state because of that medication. So in order to determine whether an individual with a disability under the updated regulations, you have to look at them in their unmitigated state. What does that student look like without their ADHD medication? So sometimes when we tell our clients that, the response we get is, I've never seen that kid without their medication, so how would I possibly know? And that may be the case, although somebody in your district very likely already has. There may be people who have seen the child before they started taking the ADHD medication, and that's information that can be considered. And then their parents can also probably give you some good information about what that child looks like when they're not in their medicated, when they're not on their medication. So the reason for this change was to expand the coverage. Our Congress wanted to expand the scope of individuals who are entitled to the protections under the Act. And there's an ADA case out of the Supreme Court about an employee with carpal tunnel syndrome. And this is an employment case. This wasn't in a school setting. It was a manufacturing case. But again, we borrow from the ADA for our interpretation. So he was a manufacturing employee and he was able to work on the line when he had a brace. He was doing fine with his carpal tunnel when he had his brace while he was working on the line. But he claimed he was an individual with a disability entitled to protections under the ADA and that he was being discriminated against because of that disability. And the trial court said, you're able to do your job, so you're not substantially limited. And that was true. While he was wearing his brace, he was able to do his job, but he was still alleging that he was being subjected to some type of discrimination based on this disability. And this went all the way to the Supreme Court. And the Supreme Court said, no, you need to be looking at him in his unmitigated state. And unmitigated, he is substantially limited, or I guess what the Supreme Court said is you need to go back and determine whether he would be substantially limited without the brace in his unmitigated state. And if so, then he's entitled to the anti-discrimination protections under the ADA. So that's how we got to this. Congress expanded the scope of the ADA. It was their way of telling these trial courts that they got it wrong and that this is an anti-discrimination act and it should be read very broadly. And that's one of the ways they expanded the scope. So we know we can't consider children in their mitigated state when we are determining whether they're entitled to protections under 504. But what are mitigating measures? So again, there's a list in your materials. It's not an exhaustive list, but medication, so the ADHD medication, hearing aids, the use of assistive technology, and what you'll see the most often are the last two: reasonable accommodations and learned behavior or adaptive neurological modifications. So shortly after the 2008 Amendments Act to the ADA, there was a district who had an individual who asked for 504 accommodations on their ACT. This individual was a junior in high school, ranked in like the top 10 or so of his class, doing really, really well, and wanted extended time on the ACT. And the district said, you're not an individual with a disability, and we're not going to give you a 504 plan. And the family took that to OCR because they had a letter from the American Institute of Dyslexia that said the child had dyslexia. And despite the fact that the child was doing well in school, the child had dyslexia. So the district said, well, yeah, maybe so, but there aren't any effects of that dyslexia in the classroom. And so they're not an individual with a disability. The child doesn't need extended time on the ACT. And so they said no. So OCR said, wait a minute, you looked at the child in their mitigated state. Because if he has dyslexia and he is as successful academically as he's gotten as far as he has, top 10 of the class, he's probably learned how to do things on his own, like how to chunk or how to context clue read, all the things you would teach him anyway as a student with dyslexia. But he's doing something. He's got these learned behavior modifications that's listed in the mitigating measures. And that's why he's appearing as a student without a disability. That substantial limitation isn't showing through, it isn't manifesting. And when you said the child was not affected, you looked at him in that mitigated state of applying those learned behavior modifications. So they said, can't look at him in that state. You need to go back and do it again and reevaluate. So that's a real live example. I'm going to come back to the student later in the presentation, but that's an example how mitigating measures affects the analysis. So another change we got with the 2008 regulations is episodic impairments. So like temporary impairments, but they're recurring. And if something is recurring, it's going to qualify as an individual for protection if, when it's active, it substantially limits a major life activity. So it does not have to be something that is ongoing all the time, or that the person suffers from a substantial limitation, 24/7. But if it's something that recurs, you look at it while it's active to determine whether or not they have that substantial limitation. Just a quick thing, final thing we got from the 2008 regs is information about the use of drugs and alcohol in the public school setting. I'm not going to go into great detail here, but I do want to alert you to the fact that there is guidance that exists on this point. And the guidance essentially says that if someone is in recovery, then they qualify for protections. But an individual who is actively using drugs and alcohol is not in active recovery, and they do not have protections under the Act. So we also have very clear language that agencies can take disciplinary action for the use of drugs and alcohol, even if the individual is in addiction. All right, so let's talk about evaluation. How to determine whether someone is an individual with, first we've talked about how we determine whether someone is an individual with a disability, but now we're going to talk about how to evaluate them on that particular case by case. So one thing to keep in mind is that anyone can refer a student. It can be a parent or a teacher, and it can be the student. So anyone can make a referral. A referral does not necessarily have to be in writing. You may have things in your policy that indicate that they should be reduced to writing, but that doesn't mean that there's not a referral when it first comes in. But it has to be, the referral can come from anyone, and then there's an evaluation requirement. So once you have a referral, you evaluate before an initial placement. You can't write a 504 plan, of course, without, you can't write a 504 plan without an evaluation. It's a requirement. And you can't delay an evaluation under 504 because of another process, because of RTI, because of ELL services. You can't require those processes as a prerequisite to 504. When you get an OCR complaint, that's the very first thing they ask for. Give me the 504 evaluation and the plan. And if you did a plan without an evaluation, then you're already out of compliance right off the bat. So there's no way to get past that first document request from OCR. You have to evaluate before you do a 504. So what does a 504 evaluation look like? Well, evaluation under 504 does not look anything like an evaluation under the IDEA. As you probably know, the IDEA has pretty complicated procedures, right? You've got to have this whole group of people involved. Evaluations under 504 can be as simple as a group of persons knowledgeable about the student sitting down to discuss the information they have. It might include testing, it might not. It depends on what the situation is with that child. It's probably going to include a review of any information the parent has given you, but there's no requirement that you have some properly constituted ETR team. So if you're talking about a diabetic student, it might just be the nurse and the parent and maybe or maybe not the student, and that's it. All right, so consent and due process. You do have to have consent to evaluate. It says, OCR has made it clear that consent is required, and that's usually right on the form. Parent is consenting, parent signs, you've got your consent. So when do you evaluate? There's no written timeline or requirement in the 504 about when 504 evaluations have to be conducted. There is nothing that says you have to do a triennial review. However, your board policy or local procedures may dictate that timeline. So you need to know your own procedures. Lots of board policies say we're going to do a triennial review. And if that's the case, then you do need to do that. But some of them don't say that. And even if it's not a legal requirement, there are 3 times when you are required to evaluate, and you have to look at these as you're thinking about the timing here. The first is that, of course, you have to do an initial evaluation like we just talked about. You also have to evaluate before a significant change in placement, and you have to evaluate when conditions warrant. That's pretty broad. That's the catch-all. So what does that mean? It means whatever you decide it means, and that's where you get those board policies sometimes that say it's going to be a triennial review. That might be what your local decision has been about when conditions warrant on an objective basis. When a child transitions buildings, or every year or every 3 years, whatever you decide, or when something comes up with that student that warrants an evaluation, then that's when you need to evaluate. If you see a change in the way a student is functioning, that's when conditions warrant. Other than that, though, there's nothing in the law about when you have to evaluate other than those 3 things. So initial, significant change in placement, or when conditions warrant. And once you evaluate, you found the child, you evaluated the child, and what now? So you gather a group of persons knowledgeable about the student, the meaning of the data collected, and the placement options, and you review the data, and you have a meeting. So just like with the evaluation, do you need a general educator, a special educator, a person who can interpret the results, a district representative at the table? You do not need all of that. 504 doesn't require it. It's just not as complicated. But you come to the table and you decide 2 things. You decide whether the student qualifies with a disability under Section 504, and if so, whether the student requires the provision of regular education or special education and related aids and services to meet their individual needs as adequately as the needs of non-handicapped students are met. And if the student is eligible, you're going to write a plan. And if the student is not eligible, you are not going to write a plan. But either way, at this point in the process, the parent is entitled to their notice of procedural safeguards. So one way or another, we need to be telling them, we did the evaluation, this is what we decided, and here's a copy of your rights under 504. And if you disagree with us, here's how you sue us. That's basically what you're handing them. You have to give them their procedural safeguards, and that is a requirement. So that's when that happens. One question we also get, we get this question a lot, is that if you use software that has a prior written notice for 504 students, that is not required. There is nothing in the law that requires you to use, that PRO1 form, that same kind of form. That form has more procedural requirements in it than you're required to give. Those 5 sections of what was the decision and why and what else was considered. You don't have to do all of that for 504. You have to give them notice of the decision, and you have to give them a copy of the procedural safeguards. On this date, we met, we reviewed this is what we decided, and here are your procedural safeguards. That's all they're entitled to. We think, and you may have heard some of my colleagues say this as well, that using those PRN, those prior written notice or PRO1 forms in that situation is confusing to parents. I don't know if you've ever experienced this, but I have had parents who think their child has an IEP when their child does not have an IEP. Their child has a 504, and they don't know the lingo, they don't know the language, but it's very confusing when it comes to what their rights are and what their child's rights are. If you, if you start giving them the types of documents that someone with a child on an IEP would expect to see. Okay, so let's talk about writing the plan itself. So there is an LRE requirement. The placement has to be the LRE for this student. And it means the same thing under 504 that it means under the IDEA. So this is to the maximum extent appropriate. The students shall be educated with their non-disabled peers. And there is also a FAPE requirement. Of course, the child must receive a free appropriate public education. which is defined as the provision of regular or special education and related aids and services that are designed to meet the individual educational needs of students with disabilities as adequately as the needs of students without disabilities are being met. So it's same language. So notice it doesn't say we're going to give accommodations. People tend to think that 504s are about accommodations only, and that's not accurate. So FAPE for purposes of 504 can include special education and related aids and services. If you have a student with a disability under 504 who doesn't meet the specific criteria under the IDEA eligibility categories, they may still require special education or related services, and that would go on a 504 plan. So the definition of FAPE does allow special education to go on a 504. People often think, 504 is accommodations only. But 504 requires us to make what we have accessible to students. So it may be that we put some special ed on a 504. It's a local decision. Many districts will start with an IDEA evaluation first because they've made the decision that if the child is going to qualify and the child needs special education and related services, the district wants to pull funding for that child if you're going to program for it. But if you're going to do the full-blown, you can do the full-blown IDEA evaluation, and that is, again, that's a local decision, but there's more than one way to address it depending on what the child's needs are. So the scope of services and accommodations. Accommodations have to be reasonable. I'm sure you all hear the phrase, it's reasonable accommodation. It's not, every accommodation. You don't have to provide an accommodation that isn't reasonable. The question is, what is a reasonable accommodation, though? How far do I have to go, and where do I draw the line? So the answer is you draw the line when you fundamentally alter the program. That's when you're no longer in that reasonable accommodation realm. And so, for example, how much extended time is too much time? At what point does that, does that fundamentally alter the program? And it's really something that comes up with twice exceptional children, as I'm sure you can imagine. Many of you may have seen this. But let's say you've got a child with ADHD and anxiety, but they're also gifted. And they're in accelerated classes, but they have a 504 plan that says they only have to complete, 75% of the reading assignments, or 75% of the work, or 60%, or whatever that number is. We hear a lot of pushback from teachers on that. I don't know if you've experienced this personally, but a lot of times we have the teacher saying, this is an AP class. And when you reduce the workload to 75%, it's not an AP class anymore. And so that's a fundamental alteration of the program. That's the argument that people make. Well, you can't condition the student's receipt of your services of that AP class, on them forfeiting their right to accommodations that are in their 504 plan. So that's the rub. So you do have to make reasonable accommodations in that setting, but there is a line that you cross where it is a fundamental alteration, and you just have to figure out where that is. It's a case-by-case basis, though. There's no bright line test. So if you're reducing the work to 50%, yeah, maybe that's a fundamental alteration, but maybe 75% isn't. But you have to make that decision, based on the accommodation, based on the facts and circumstances, based on the class, based on the assignments, and what that child's needs are. It's just impossible to have a bright line test, and that makes it kind of difficult. Also remember, as you can see from the slide pictures, this is an anti-discrimination statute, and so it says you're going to make all of your programming accessible. You can't, make some of your programming inaccessible to students with disabilities, and so that means everything. That means field trips, that means extracurricular activities, that means sports programs, and this frequently comes as a surprise, not to the educators, not to the student services folks, but it comes as a surprise to coaches. And I would say it definitely comes as a surprise to parents of other students in the program or activity that are not disabled. But the obligation itself comes as a surprise to coaches, but oftentimes, even if a coach knows they have the obligation, they are not informed about the student's disability, and so they don't know that there's an accommodation they're supposed to be providing. So both of those things come up all the time, and that can be an issue. So we have an example of a student who had extended time on their 504 who tried out for the cheerleading squad. And the coach didn't know anything about it and did not give her extended time to learn the cheers. And when she tried out, she got cut. She did not learn the cheers, when she was compared to her peers, and she didn't make the cheerleading squad. So the coach in that case, though, had no idea that the child had a 504 with extended time. So the student challenged that, filed a complaint with OCR and said I was excluded from the cheerleading squad on the basis of my disability. I was not given the extended time that I'm entitled to on my 504. And so I got cut from cheerleading. And if I had been given my accommodation, I could have learned the cheers and I wouldn't have been cut from the squad. So she was, denied access to the athletic program because she wasn't given her accommodation. And OCR found, not surprisingly, that that was indeed a violation. So be aware that what's on the 504 applies across your program. So how do people know? I don't know why I get this pushback all the time, but I often have, clients that I'm talking to say, well, I can't give that information to the coach because it's private, it's FERPA protected. It's, this is the student's confidential information or their education record. But coaches have a legitimate interest in knowing about the students they're serving. They have that legitimate educational interest. And so they need to be informed about the students on their roster. And really, in a perfect world, it's routine that when a student is on a roster, the coaches are provided with the information they need. That doesn't mean they have to have access to everything. The limitation is that they have access to the records that they have a legitimate educational interest in. And if there's an accommodation that a child needs to participate in an activity, then the coach should be made aware of it. Okay, let's talk about procedural safeguards and dispute resolution. You do have a requirement to notify parents of the decisions that you make, like I said, and you do have a requirement to let them know how to challenge it. And we call it the Here's How You Sue Us notice. It has to be provided to parents in their native language. This is something that happens, pretty frequently as well. There's case law on that. If you don't give required notices to parents in their native language, that's not really notice because they can't understand it. And so it has to be translated into a language that they're able to understand in their native language. Now, under 504, there are lots of different ways to challenge a district's decisions. How the decision is challenged is mostly dependent on the nature of the dispute. So again, remember from the start, this is an anti-discrimination statute. So districts have an obligation to protect against discrimination on the basis of disability, and that includes discriminatory harassment. When you allow someone with a disability to, when you tolerate harassment, that is discrimination. That is treating that student differently on the basis of their disability. So you have to have a grievance procedure in your board policy. That's required under the 504 regulations. And that grievance policy should be how to address complaints of disability-based discrimination. You have to have at least one person designated as your 504 compliance officer, and that has to be in your policy as well. These are the people to whom the grievance is presented, whoever your 504 compliance officer is. And the law requires that you have a procedure with appropriate elements of due process. So, and that you must be prompt and equitable. Now, the details of that process, should be spelled out in your policy. They just have to be, it has to have the elements of due process, and it has to be prompt, and it has to be fair. Those are the requirements under the law. I always like to ask people in the audience if you know who your 504 compliance officer is in your district, and I usually do a show of hands, but that's kind of hard to do on Zoom. But let's just assume that if I ask that question, every single one of you would know who your disability compliance officer is. And if you don't, you should definitely look it up. I'm not going to lie. I was on a call with a client not long ago where we asked that question, who is your district's disability compliance officer? And they got out their policy and we looked at it together, and it was the person on the phone that I was talking to, and they did not know that they were the disability compliance officer. So it's really important to know who that person is, because you've got to know who to go to and who to refer people to, and it may well be you. So allegations of disability-based harassment are addressed under that grievance procedure. And of course, if discrimination is found to have occurred, then the district's obligation is to stop the harassment, prevent its recurrence, eliminate the hostile environment. So those are the obligations under your grievance procedure. Now, when there are different kind of disputes, such as disputes related to identification, evaluation, or educational placement, they can take you to due process. And it rarely happens, but if you find yourself in that situation, the district is required to find a hearing officer and appoint a hearing officer, usually from ODE, and you pay for that. And then you have an administrative hearing like a trial. There are witnesses, testimony, cross-examination, all under oath. There's a transcript, and then the hearing officer issues a decision. People can also go to OCR and file a complaint. We see that pretty frequently. That's a dispute resolution mechanism that's always available to parents and students. And then, of course, they can sue you in court. So lots of different ways that parents have the right to enforce their rights and their child's rights. So the best strategy for these kinds of complaints is to avoid them in the first place, and to be proactive. So getting trained on legal compliance is important. So good that you're here. I'm glad you're all here. Making sure that your staff have access to your policies and know what those policies are. You should document your compliance with district's policies. Documentation is key when you're in a situation where your actions are being disputed. Having documentation of what you've done, the efforts that you've taken, that's going to be key. If you don't have documentation, then a proof issue, then you have a proof issue that's unnecessary. So documentation of your district's compliance is extremely important. Make sure all of your staff members know who to call for help, know who that 504 compliance officer is, make sure they're trained on that and they know that. Train your staff on good communication and conflict resolution techniques. I can't emphasize this one enough. It's really important. Sometimes, these disputes occur because there are misunderstandings. And, if folks are communicating better, communicating effectively and learning how to work out a disagreement before it becomes a complaint, that is so important. Just sometimes if the family knows that you're taking the efforts and doing the things that you can do on behalf of that child, even if they don't necessarily agree with every step, if they know that actions are being taken, to do what's right for that child, maybe they're less likely to run and file a complaint or file suit. Paying attention when you see something changing. This is interesting. If parents start showing up at meetings and say, I want to record this, that's probably a red flag that something's wrong. If they change their mode of communication or their tone of voice, this is one that we see pretty frequently. If you suddenly notice that their emails have a very different approach, maybe they're structured like a legal argument. If that email doesn't sound like the parent's communication style anymore, they're probably not the one writing the email. That very well may be they've got an attorney or an advocate behind the scenes, and they're getting ready to, to file a complaint or to push back. So if the emails start to look like they're written by a lawyer, probably they are. So there's a red flag. If they start making broad record requests, if they're complaining about staff, there's probably something brewing behind the scenes. And it's, often a good idea to try to be proactive to see what it is and see if it's something that can be resolved before it's too late. All right. And then there are some bigger red flags, complaints that their child isn't receiving services, bringing an advocate or an attorney, actually bringing that person to the meeting when they're not just behind the scenes, requests for private placement, requests for IEEs. Those are signs that things may be escalating and that it might be a good time to take that opportunity to try to figure out what the underlying problems are and get on the same page and work together. So that is the nuts and bolts. I see that there is stuff in the chat. Let me see if these are questions, because this went.
I've been making a list, Katie, of the questions. So and just responding of the ones that we can't answer, that I have a list, so we can ask them all together. Okay,
well, we can go ahead and do that, because that's really the bulk of the nuts and bolts of the law. And I'm running 10 minutes ahead, which means I'm not, sometimes I get interrupted with questions. So I've got plenty of time.
Perfect. So one of the questions we had is if you don't have to provide a PRO1, how should a district provide notification of its decision?
So it can be a letter. I mean, it needs to be in writing, because it needs to be in writing and you want to document it, but it just doesn't have to have all those components on a PRO1 of, of what was considered and what other options and all of that. That information isn't necessary. So it could be a simple letter that says, we met on this date and we considered, this information, and this was our determination, and enclosed as a copy of the procedural safeguards. That's it.
And could they, if they chose to use the PRO1 form, would that be acceptable?
You can use the PRO1 form. Anytime you're in compliance with the IDEA, you're going to be in compliance with 504 because you're doing more than is necessary. So there's absolutely nothing wrong with using the PRO1 form from a legal compliance standpoint. It's just that it might be confusing to the parents, and you might be, taking the time and making a record or answering questions that you don't have to necessarily answer.
So if a district were to create their own, essentially kind of your own prior written notice related to 504s, as long as they,
For 504.
just so they standardized it, that would be okay.
Yep, that's exactly right.
Perfect. Can you give an example of when a student may have both an IEP and a 504 in place?
Give an example of when they might have both.
Yes.
I don't know that that's necessarily a good practice. I mean, under the IDEA, you want everything addressed in that document. So I would say that if they qualify under the IDEA, you're going to want to have everything in the IEP. If they don't qualify under the IDEA, but they're still entitled to special education, you can have a 504 that has components that look like something that might go in an IEP, if that makes sense.
Yep. And then the other one, so you talked about that cheerleader example, that one. But if the 504 says the location says general education classroom, how does that apply into sports? Would they have to put anything additional in there? Or does the general education classroom encompass the need for those sports as well?
I guess I'm not quite sure what you're saying. Are you saying the accommodations apply in the general education setting?
Yeah, so like on that 504 form, you have to say what the accommodation is, who's providing it, and the location of services.
Right.
So if it says that the location is in a general education classroom, how does that apply outside of the general education classroom?
So I think the word classroom is what's throwing that off a little bit. I mean, your extracurricular programming is part of the general education setting as a whole, right? And a student with a disability can't be denied access to any part of the program on the basis of their disability. So if you've got an accommodation that's going to be applied in the gen ed classroom, I think it's probably going to be, I mean, it's going to depend on what it is. I mean, obviously, if you've got a student who is only responsible for doing 75% of the questions on a test, that's not going to apply the same way in a sport. So it may need to be that your 504 plan has to look at that broader picture. But in general, if a student has extended time in a gen ed setting, they're going to get extended time in their extracurriculars unless it fundamentally alters the nature of the program. I mean, and I'll have an example of one that I have a couple examples coming up in the next section about fundamental alteration when you're applying accommodations to extracurriculars. So let's hold that one because I don't want to give too many spoilers. I've got a swimmer, I've got a golfer, and I've got a football player that we're going to talk about.
Perfect. And then another one, someone asked, can you elaborate on how FAPE for a student on a 504 would include special education services? Because you're not really referring to SDI, right?
You can have SDI if it's a student who doesn't qualify under the IDEA, but they need SDI to accommodate their disability that doesn't qualify. What if they have a disability category that's not one of the eligibility categories on the IDEA? I don't have a specific example, but that's the kind of situation where that might happen.
And then there was some question about where to give to find the procedural safeguards for 504s and if they were the same as for IDEA. And I had shared that there are separate sets of them. Right. So most programs such as Same Goal have them included in there. Mm-hmm. Do you know of another location where they could find those if their program doesn't have it?
Gosh, I don't know the answer to that. I would assume that there's probably a link on the ODE website to something, but yeah, I would think it would be in whatever software you're using.
And then somebody had just said, would OT services be an example of SDI within a 504 that maybe isn't specially designed instruction because maybe they wouldn't qualify? Would that be potentially an example of how that would work?
Sure, it could be, yes.
Can you think of any other examples of where SDI And I go back to, I had a student that used to qualify under orthopedic impairment, but it wasn't impacting, but we still needed to add OT services because he still needed, or I'm sorry, we did PT services
Mhm.
because he still needed some additional instruction on, he was trying to transition from a wheelchair to crutches or wheelchair to a walker,
Mhm.
but we didn't have it as, he didn't qualify under any of the other categories under us, you know, just those physical therapy needs alone. Can you think of any other options?
I can't think of any off the top of my head, but I wrote myself a note. Let me think about that and see if I can come up with something.
Thank you. And then I have another one.
Okay.
What would you say? I know that it says like 504s need to be periodically reviewed.
Yes.
What would be your best practice? I know periodically is not a defined term, right? So what would you suggest would be best practice on how often a 504 should be reviewed?
So your best practice is to make sure you're effectively serving the student, right? So it's going to be case by case. There can't be a best practice. If you've got a student who things are changing, you're seeing something different, that's going to be a time to reevaluate. If you've got a student who is changing buildings and their programming is going to look different simply because they're in a different building, that's something that it would be a time to trigger it. A lot of districts' policies say that it's going to be triennial. So you're going to be doing that anyway, periodically. I certainly don't think, there's no bright line test. I wish I could give you, a roadmap, but unfortunately there's not one under the law. But I think that the important thing is that you're effectively serving the student. So if you're being aware of things that change that would trigger the need to evaluate and think about, what those students' needs are, then you're going to be doing the right thing for that student. So that's what the important thing is. It's based on their unique needs. Sorry, I know that's lawyer talk, but it's true.
No, I've been asked that question a lot, even when I was in a district. So, and that's kind of,
Yeah.
some students we were okay with not having to,
Sure.
like my own daughter, for example, her extended time or not being allowed those breaks because due to her Crohn's disease, but it hasn't really impacted anything else.
Mhm.
Like I don't need to bring a whole team together. Like she has it, we know this, we know what her needs are.
Yeah, that's a perfect example. I guess there's certainly nothing wrong with having, a set time frame. But the problem is when you start to say, here's the bright line test, and this is when you should do it, that might give you that false sense of security that you're meeting that child's needs just by following the bright line test when you're overlooking the more important issues based on the unique needs of the child.
And then we've had some, so I'll just kind of address where I've seen people helping one another, saying they're not seeing the procedural safeguards within systems like Single.
Oh, okay.
And most of them are saying that those pop up when you actually say to print the document, it shows up at the end. So those documents, all of the systems I've ever worked within are there in my previous experience before coming to the SST.
Right. I thought they were there. I've never had I don't think I've ever had a client ask me where to find them. I thought they were in the software. So yeah.
Yeah. So if they're not, if you aren't able to locate those, I would talk to whoever oversees that, working with your ITC. That would be my suggestion to those of you in your districts, to talk to someone and find out where those are, because they're probably there and it's just locating where they're invited or where they're included.
So the next part of my presentation is I've got we call it our FAQ section, but these are the kinds of questions that we often get, and we can kind of go through some of these together. But they are questions that we've gotten in our office that deal with all of those same issues we were talking about in the first hour. So my first FAQ on the slide is, if a student is not eligible under the IDEA, might they still be disabled under 504? So the answer is really maybe. So if you look at this little visual on this slide, it shows the yellow circle in the middle is going to be your population of students who are eligible under the IDEA. Those are those students who qualify. So that means that student has a disabling condition as defined in the IDEA that causes an adverse effect on their educational performance and needs special education. So that's going to be your IDEA. The blue circle, which of course is bigger, includes every student with a physical or mental impairment that substantially limits a major life activity. So it's much broader. It's gonna capture a larger population of students. So if the student doesn't fall in the center circle, they very well may still fall in that second circle. So keep in mind that when we're talking about an individual with a disability, remember it's an anti-discrimination law, and it borrows from the ADA. So nowhere in the law does it say that it's a child or a student. So the protections of 504 apply not only to students, but also to the adults that work in your buildings, your employees, and to visitors to your school campuses, because it's about accessibility. So because you're a recipient of federal funds, you have to make your programming accessible to students, employees, and visitors. And that's why, when you put on a school play, you can have you have an interpreter, and you have to pay for that. If you have members of the public, or because you might have members of the public who want to access your federally funded programs, you have to make them accessible. So it's very broad coverage. Anyone who's been in the schools for a long time knows that 504 is, a lot bigger than it was 10, 15, 20 years ago. And that's because of the expansion of those regulations and the way we are now reading it, because that's the way it's designed. So it's an anti-discrimination statute. Number 2, do we need a medical diagnosis to establish an impairment? You may recall, if any of you were in attendance at the first session in this series, in that section, we cover a lot of, we spend a lot of time covering the difference between a disability and a diagnosis. And I don't know if Laura Anthony presented on that, on this topic this year, but she often does it. I know when she presents on that discussion, she talks about the big D and the little d. We've got the big D disability and the little d diagnosis, and they're not the same thing. She sometimes makes a reference to a TV show from the 70s called The Letter People, where the letter represents, something that starts with that letter. And that's what she's talking about, the big D disability, not a little d diagnosis, because they're not the same thing. So don't assume that a medical diagnosis is required. There is nothing in the law that requires a medical diagnosis to determine that someone has, or to determine whether someone has a disability and is, protected under 504. Now, if you truly believe that a medical diagnosis is necessary for you to reach a determination, you can certainly ask for one. But remember that it's a free, appropriate public education. So if you're going to ask for a medical diagnosis, you have to pay for that medical diagnosis. That can't be something where the cost is passed on to the student or the parent. So it has to be free. So if you believe you need a medical diagnosis for a particular child, you have to obtain it at school district expense. And you also can't require it. You cannot require a parent to provide a diagnosis. You can't say, we can't consider, whether or not your child is qualified as a child with a disability without a medical diagnosis. So you have to do it and force them to sign a consent form. You're not allowed to do that. So that's up to them. But, it's in most cases, you probably don't need it. If the parent refuses consent when you think you do need it, then you just have to rely on whatever information you have available, and make your determinations that way. So let's say you've got a child that you suspect has ADHD, a child that you think isn't concentrating, but you have no diagnosis. So you're going to look at the data that you have, and you probably have a lot more data than you think. So records of their behavior, aptitude and achievement tests, academic performance, records of any medication they're taking at school. That may give you some insight into their the underlying medical need, disciplinary records, reports from teachers, and then reports from the parents. So that information is the information available, and that's what you base it on if you don't have a diagnosis. But you probably have quite a bit of information that you can be looking at to determine, whether the student has an impairment that substantially limits a major life activity of thinking or concentrating. So you probably have what you need without a diagnosis. But what you're doing here is making your program accessible. You're not charged with making medical diagnoses. If you have them, you consider them. If you don't, you consider what you have. So to put this in perspective with ADHD in particular, this is one of the areas where I want to point out a Dear Colleague letter, one of those guidance letters from OCR. So again, this isn't law, but this has been around since 2016, and this tells you how OCR is going to interpret the law. This is a really long letter. It's like 20 some pages long. So, this one, there's a lot of meat to this one. It's definitely worth, worth taking a look at if you, in your spare time. I'm sure you all have spare time where you're thinking, oh, I think I'll go read a Dear Colleague letter from OCR. No, but if you do have time to peruse this one, it's a good one because it's got good information in it, but it's also summarized in your materials for you. But this letter was aimed at school districts on the issue of identifying students with ADHD under 504. And OCR had reached the conclusion that this is a big population that's being overlooked, a large population of students that are being overlooked, and that school districts were failing because they weren't identifying these ADHD students and serving them appropriately. So this letter is about the failure to identify and evaluate students who may need accommodations. So first it says that the district staff are the eyes and ears of the district for child find purposes. And so teachers who are working with kids notice things that could suggest that a student might have ADHD. And then they give examples of restlessness, inattention that's inappropriate for the student's age, trouble organizing tasks and activities, communication deficits, difficulty beginning tasks, organizing or recalling information, rushing through tasks, or producing messy work, careless mistakes, and difficulty completing assignments. So if you see those things in a student, they're saying that could suggest that the student might have ADHD. I don't know about you, but I know a lot of kids who meet those criteria. But what they said, though, is what they're essentially trying to say is that you've got to be paying attention, because these types of things that you're observing may be telling you that you have a child find obligation, and an obligation to program for these children. So then they went on to say that a medical diagnosis may not be required, as we just talked about, but OCR is going to presume, unless there's evidence to the contrary, that if a student does have a diagnosis of ADHD, that they are substantially limited in one or more major life activities. So what that tells you is reinforcement of what we just said, diagnosis not required. But if there is a diagnosis, OCR will presume that that child is substantially limited in one or more major life activities. So it becomes the obligation, if you don't think that's the case, to have evidence to the contrary. So the presumption is sort of backwards, but that's the way they're going to look at that. So if you know that a student has an ADHD diagnosis, presume they have a substantial limitation of one or more life activities, and then that's it, unless there's evidence to suggest otherwise. So then if you're going down that route where you don't think the child is substantially limited, you would need evidence from your staff that the child is able to concentrate in a distracting environment, even though they have that diagnosis, that they are performing well, that they're not distracted, that they do their homework, neatly and without careless mistakes, that they turn their assignments in, that type of evidence to counteract that presumption. And if you don't have it, OCR is going to assume that the child qualifies. And that means that they qualify. So then you have to determine whether they need services to accommodate that disability. But again, OCR said you do not need a medical diagnosis. So the takeaway is that you can't use the academic success of a student to conclude they're not substantially limited. So those mitigating measures we talked about. Someone with ADHD may achieve a high level of success and may nevertheless be limited in a major life activity due to their impairment, because of that additional time that they have to put in, to get their work done. So they're getting all A's, but it takes them 8 hours to do their homework. Or a parent is telling you, my child's completely stressed out. What that parent may be telling you is that the child is using mitigating measures, and doing more to compensate for their disability. So just be aware of those arguments. Okay, did I really mean it when I said you can't consider mitigating measures? Well, yes, I meant it, but sort of. Okay, so I'm going to qualify that. So go back to, sorry, I wanted to make sure I'm on the right slide. Go back to the student we talked about earlier with the diagnosis of dyslexia, who was, ranked high in the class, that student who was top 10 junior in high school and had the diagnosis of dyslexia. doing great in school, but wanted extended time on the ACT. And you remember the district said, we're not evaluating this kiddo because this child's doing fine. And OCR said, no, you're looking at him in his mitigated state. He's using, learned modifications, and you need to evaluate him. Okay, so the district went back and evaluated him after the OCR complaint, and he qualified, because when they looked at him in his unmitigated state, they determined that he did have a limitation of his, a substantial limitation of the major life activity of reading. And, so when they considered him in that unmitigated state, but any accommodation that the district could possibly give him, he already had it. So he didn't need anything, even though he qualified, but he didn't need anything in terms of accommodating that disability. So while he qualifies as an individual with disability, so he's subject to the anti-discrimination protections, the district didn't write a plan because they determined that he didn't need it. So can you have a student who qualifies but doesn't need accommodations? The answer is yes. So that's what what you can do with that kid. So there is language from the Dear Colleague letters on this issue. I think it's in the middle of page 12 in your materials from OCR's Q&A back in 2012. And it says that although districts may no longer consider the effects of mitigating measures when making disability determinations to determine whether the person qualifies as an individual with a disability, those mitigating measures remain relevant in evaluating the needs of a student with a disability for special education and related services. So when you're determining whether or not someone is disabled, you cannot consider mitigating measures. But when you're determining their need for services, you can. So that's the distinction. So they're certainly protected from discrimination because it's an anti-discrimination statute, but they may not need special education or related services or accommodations. So you can consider mitigating measures for that point. So that student still did not get the extended time on their ACT. All right, the next question, if the student doesn't need services or accommodations, what responsibilities do we have? So what do you do? What are your responsibilities to a student who qualifies? So maybe the student with the dyslexia diagnosis, but who doesn't need accommodations. Well, you need to provide notice. And this is going to look like what we talked about right before the break, or it can, you can use that form if that's what you're used to using, is that PRO1 form. But you say, we evaluated you, that this is what we considered, and we determined that you are indeed an individual with a disability, but you do not need services, so we're not writing a 504 plan. And then you provide them notice of procedural safeguards, but you don't provide services and you don't write a plan. So you don't have to write a plan just because someone qualifies. They have to need the accommodations and services on the plan. So if they don't need anything, then you don't need to write a plan. Okay, question 5. We get this one mostly in the spring, but we do get this question, it seems like, multiple times a year. Does the district have to send a medical attendant on the district's 8th grade trip to Washington, D.C.? Do I really have to send them? And the answer is maybe. So going back again, this is a statute about access. If a child needs a medical aid in order to access your district sponsored program, then the aid is going. If that's what they need to be able to access it, they're entitled to it, because you can't deny them the benefit of participation in your program, that's supported by federal funds on the basis of their disability. So then what happens is the special ed director says, okay, we're going to send the aid. And then, they have to talk to the superintendent, and the superintendent says, how do we pay for this? That's another issue. But, we'll talk a little bit about cost as a burden. But the next question we get though is, what if we make the parent go? Can we just make the parent go? And the answer to that is no. Of course, you can't make the parent of a disabled student go unless you're making the parents of all of their non-disabled peers go as well. So you can't require it. That's discrimination. That's treating that student differently on the basis of their disability. But you can ask the parent to go. And sometimes the parent wants to go. There's absolutely nothing wrong with that. Sometimes the parent feels more comfortable going and making sure that that child's medical needs are accommodated. And they might say, yeah, that's fantastic. I'm going to go. The The student may not like it. They may not want their parent to go, but that's not the issue. The bottom line is you can ask a parent to go and perform that service that's needed for the student, or be that student's aid, but you can't require it. So then we get, do we have to pay for the parent to go? Well, you'd have to pay for somebody else to go. So, you know, you may be covering some of the costs for that parent to go. It's probably going to cost you less if you're just covering their trip costs and not also paying them as an employee to provide services on the trip. So it still may be something that's cost effective. But you know, what you really want to do in this situation is try to get in a place where nobody's arguing and everybody's in agreement, you know, to make it accessible. What if you want to exclude a student with a disability from that program? Can you do that? Well, you know, if they have terrible behavior or if they're medically fragile and you want to exclude them from participating in this trip. So I would definitely caution against denying participation to a student with a disability. But that's not to say that there aren't legitimate reasons when you might exclude a student. So for instance, if you've got a student who's been suspended or expelled, you might tell all your students across the board that, you know, whether they're students with disabilities or not, that policy applies to everyone, and that anyone who has been suspended or expelled, you know, this semester is not eligible to go on this trip. You can apply that uniformly. Or you might have a GPA requirement. You know, you have to have a 2.5 in order to go. Those are legitimate non-discriminatory reasons where someone with a disability may legitimately be excluded. Sometimes we're asked about excluding a kid from playing sports because of a disability. So we're not talking about the Washington, D.C. trip, but here's the basketball student example that I told you I was going to give you. So we had a student with a student who wanted to play basketball, and the student had been in a car accident and they had a traumatic brain injury. And they wore a protective helmet because of this brain injury. But in this case, the student wanted to play basketball and wanted to play without the helmet. And the superintendent didn't want them playing the sport at all, but certainly not without the helmet. And the parent didn't want them to wear the helmet. So what you have to do in that situation is get the best medical information that you can. So in this case, the parent signed a release. So the district was able to communicate directly with the doctor, which, you know, it's always so much better if they'll sign that release so that you can get direct information that's not being filtered or modified or, you know, the game of telephone through the parent. But the doctor said, there is no way I would ever allow this kid to play a contact sport without their helmet. And actually, I wouldn't let them play it with a helmet. This child should not be playing a contact sport at all. And so that was helpful because then there was a legitimate medical reason to deny the student the opportunity to play basketball. And that what the doctor said was that the child's participation presents an unacceptable risk to the student's health or safety. And that's the standard. So, you know, go get the best medical information that you can on what those students' limitations are. And if you can't have access to the doctor, you know, you just have to do the best you can with what you have, but try to get the best medical information you have to make those kinds of determinations. What about a child with seizures? A child who's having a seizure occasionally, but not every day. So this is an episodic impairment that when active is a substantial limitation of a major life activity, but it doesn't happen all the time. There's a case in your materials about this where a district put some protocols in place for the child's safety. And basically what it said is if there is a seizure on the day of the field trip, then the student is not allowed to go that day. If the student is seizure free that day, then they let the student go. And that was determined to be reasonable. That's a reasonable limit. So they let the student, in this case, you know, the case came about because the student had a seizure and was denied participation on a particular day to a field trip. But that student had been allowed to participate in 18 other field trips that year on days when the medical condition was not an issue. I don't know what program that kid is in, but 18 field trips in a year sounds like a lot to me, but they got to go on all of them except the one on the day they had the seizure. And in that case, I think what was really most helpful to the school is that they had a procedure. They had, you know, a protocol in place and they followed their protocol. So it didn't seem like a haphazard or arbitrary decision. We're not going to let you go today. All the other days of field trips when the student was seizure free, the student was allowed to go. So it just goes back to that standard of whether the child's participation poses an unacceptable risk to his or her health and safety. And those decisions, have to be made on evidence, not on assumptions. And in this case, the court held that the protocols were appropriate and they were uniformly applied. Okay, next question. We've definitely talked about this a little bit, but do 504 plans apply to athletics and extracurriculars? So we talked about our cheerleader, and I have that follow-up question. So I'm going to give you some more information about the same cheerleader. So she gets extended time on her 504. She gets extended time to learn the cheers. So now for the rest of the story. So she came back and tried out again, same cheerleader the next year. And this time they gave her extended time to learn the cheers. And we went back to the coach and said, you need to have a rubric that you're following when you're evaluating all of the cheerleaders as they're trying out. Give her the accommodations and then apply that objective criteria to determine whether or not she makes the cheerleading squad, and apply that same objective criteria to everyone. So that's what they did. So guess what happened? She didn't make the team again. So she filed a retaliation claim. And, we knew this might happen, but she tried out with the extended time. She still didn't make the team based on this objective criteria and the rubric. So when the retaliation claim was filed, the district went to the coach and said, okay, I need the documentation of your rubrics that you used, because that's our evidence that we applied this objective criteria, after we gave her the accommodation. And the coach had thrown the rubrics away. So I do mention that just because that's the kind of thing where, they did everything right, but they didn't document it right. And that's a piece of it, because it's hard to prove that you did something if you don't have the records of it. Those are records that need to be created and then maintained. So the takeaway here is you have to have legitimate non-discriminatory criteria if you're going to exclude someone, so that they don't prevail in an argument that exclusion was actually based on their disability, that it was discriminatory. And then don't throw that legitimate non-discriminatory criteria away. In this case, the coach reconstructed the rubric and gave an affidavit, and that was better than nothing. But how does the coach know what accommodations the student is supposed to get? Sometimes districts require coaches to review their rosters, pull files, and see what they're entitled to. Like I said earlier, this is not a FERPA issue. The coach has a legitimate educational interest in that information. And so they can provide, in order to provide them equal access to the program. So we want to make sure the coaches have the information they need, and they definitely need to know that. So any, accommodations in a 504 plan are going to apply across all settings to the extent that they're applicable to that setting, like we talked about earlier. So then you've got to also grapple with whether or not the accommodation is reasonable. The limitation being that if it fundamentally alters the program, then it may not be a reasonable accommodation in that context. So, consider a basketball player with a hearing impairment. They may need an interpreter in order to allow them to communicate with their coach or their peers. That's not going to fundamentally alter the nature of the program. Or a student with migraines who may need to be permitted to have an alternate tryout day if they suffer a migraine on the day of tryouts. Now, there's a case on the top of page 15 in your materials. This is a student who had an emotional disturbance, and in their IEP, it said that they were going to be given re-cueing, and he was going to be permitted to line up last for activities, just in general, not specifically applying it to the extracurricular setting. Well, this child played golf, and the golf coach was made aware of these accommodations, but the golf coach refused to provide them. And the golf coach said, this is going to be unfair to the other kids on the team for him to have extra coaching or to let him always go last. I'm not going to do that because that's not fair to the other kids, and that's not a reasonable accommodation. The student filed a complaint with OCR, and OCR said that that's not a good excuse and that it should apply in this context, that is not a fundamental alteration for that one student to go last or for that student to get some re-cueing. Now, I would say that, if you've got a situation with a football player who needs re-cueing in the middle of the game after the ball is hiked, that's going to be a problem. So that might be a fundamental alteration of the program if we're going to have to stop the football game and re-explain the plays. So, you have to be looking at the program and whether or not it truly is a fundamental alteration. But if you think about the golf, it isn't a fundamental alteration for one person to go last. Someone has to go last, and that's just the way it plays out. But I think the real important thing is to notify coaches to make sure that they know what's required, make sure they understand that when we're talking about selective activities, they need to use non-discriminatory reasons for selection. It doesn't mean automatic access. Every student with a disability doesn't necessarily get to be on the team that they try out for or participate in the program that they want to try out for. It's not about automatic access. It's about equal access and having that equal opportunity. And then, discuss those accommodations with coaches and revisit them as needed. And that'll keep you out of hot water in your athletics and other extracurriculars. Okay, we often get asked if we can provide a list of reasonable accommodation. So what do you think the answer is this? Can you provide a list of reasonable accommodations? Nope, we can't do that. No. A lot of board policies and 504 forms have checklists in them, kind of like a menu. Here are your reasonable accommodations. What would you like to order? And checklists are good and bad. I mean, checklists are great because they help you think creatively. They give you ideas. They give parents ideas about the scope of things that might be available that they may not have thought of. So there's nothing wrong with having, ideas and suggestions and checklists. But it's not supposed to be a menu where we pick and choose. And, it's certainly not supposed to be a mathematical, calculation of this student has this disability and they want to do this. And so we're going to accommodate them in this way. That's just not possible. It has to be an individualized discussion. Now, that doesn't mean to say that you're not going to see similar types of accommodations for similar types of disabilities, because some types of disabilities create, similar needs. I mean, there's certainly going to be some repetition and predictability to them in some ways, but it can't just be, if I have a student with ADHD, they are going to get breaks and extended time of this amount. That's just not the way you look at this. So I can't give you a list. It can be anything, but the real question is how far you have to go. And as I said earlier, you look at this, or we see this a lot in the context of a twice exceptional student. Just to be able to understand what your obligations are, you have to borrow from the ADA, and that's that interactive discussion. That's what that really entails. And so it's going to be something where we talk about what their needs are, and we talk about what the potential accommodations could be and how we can work with them. So when an employee comes in, that's an employee, and says, I need, X because I'm disabled, under the ADA, the employer is required to sit down with that employee and talk about what they need, talk about what's reasonable, see what we can do, and have this interactive discussion. And it's the same thing with your students, and of course with the parents that are involved. So when we're defending where that line is drawn, where you say no, or that's not reasonable any longer, it's always going to be an easier defense if you've provided some accommodation. So if they've asked for, a certain amount of extended time, and you determine that's a fundamental alteration, that you've cut that back, but you've still offered some extended time, that it's not nothing, that when they ask for accommodation that you determine is unreasonable, you still give them something so that you accommodate them, but just maybe not to the extent they're requesting it. Don't just say no because it's an AP class. But like I said, you don't have to give them the full amount of time that's requested if it's not a reasonable accommodation. Or if it fundamentally alters the nature of the program. And there is a line. The hard part is just finding where that line is. When the requested accommodation is not given and it's challenged, if you've provided something, like I said, it's just going to be a whole lot easier to defend. Even if, you really conclude that what they've asked for is a fundamental alteration. So on the topic of fundamental alteration, I'm going to talk about a high school swimmer. This is a real case that we saw. So a young high school student joined the swim team, and she had a fear of drowning. I don't know about you, but I don't know why she joined the swim team. That seems like a stretch to me if you have a fear of drowning, but maybe it was, exposure therapy or a way of trying to overcome that fear. But she wanted to be on the swim team despite her fear of drowning. And so she, felt maybe she needed to get in the pool to face that fear, but for whatever reason, she joined the high school swim team, and she went to the swim coach and she asked for an accommodation of, I need to be able to leave the pool when I have a panic attack. Even if I'm in the middle of a swim meet, I need to be able to get out. And the coach said, yeah, that sounds like a fundamental alteration. We need you here. We need you on deck. We need you in the water. We need you swimming across the pool when you're in a race where you're supposed to be swimming across the pool. And you can't engage in competitive swimming if you leave the pool. And so the coach said, no, that's a fundamental alteration. And the family filed suit. They didn't file a complaint with OCR. They went straight to court. They filed suit and they alleged that this denial of a reasonable accommodation, in the athletic program violated their students' rights to access that program under 504. And the court said, the court said the swimmer has to swim, that it is a fundamental alteration of the nature of competitive swimming to accommodate a student by telling her she doesn't have to swim. So you can't leave the pool in the middle of a swim meet. Staying in the pool is an essential aspect of a swim meet, of being a swim team member. And so the court did hold that that was a fundamental alteration. So, I feel like that took it to the logical conclusion. That makes perfect sense to me. So, but you do have to take it pretty far to say that it's a fundamental alteration. The other example, I think, which is not a real one, but a hypothetical, is that football game. I do think that if a student is saying that they need recueing in the middle of a play at a football game, that's probably going to be a fundamental alteration of the program. The other thing that's really hard to defend, though, and I alluded to this earlier, is when your reasonableness analysis hinges on cost. When you say, I can't do that because it's too expensive. I can't provide that aid to go on the DC trip because it's too expensive. When OCR considers whether something is unreasonable in terms of cost, they are looking at that cost in comparison to your entire district budget, not that program budget or that activity or even just that building. They're going to look at your entire district budget and determine whether or not the cost is unreasonable. So whatever someone is asking for is not usually going to be considered unreasonable in light of the entire district's budget. So you're probably going to lose on that. So that's the best, we can give you on fundamental alteration in terms of, drawing lines. They're just hard to do. Okay, question number 8. Must a district conduct a manifestation determination for a student protected under 504 before imposing disciplinary removal of 10 days or more? So let's go back to when you have to evaluate. Like we said, there's not a specific timeline, but you have to evaluate at the initial determination, before a significant change of placement, and when conditions warrant. So the answer is going to be yes. Because that's going to be a significant change of placement. So if it's fewer than 10 days, OCR has found that's not a significant change of placement. So you don't have to do an MDR. But just like under the IDEA, a series of suspensions or a pattern of removals that cumulatively totals 10 days in a school year, that's still going to be considered a change of placement. And that's not different under 504. It's the same under the IDEA and 504. So look at a student's suspension history when you're determining whether or not that 10-day, requirement has been met. But this manifestation determination, review concept, it predates the IDEA. It existed in 504 long before the IDEA was ever adopted. And the idea is that if you take a kid out of their educational program because of something related to their disability, that is the ultimate act of discrimination. They engaged in some sort of conduct or behavior because of their disability, and then you kick them out of your program. That's exactly what we're talking about here. So that's discrimination. So you evaluate and make sure you're not denying the student access to your programming because of that disabling condition. So yes, you do have to do an MDR for students on 504. So go back and think about those individuals who are entitled to the protections of the act, but who don't require a plan. Remember at the very beginning, we talked about students who have a record of impairment, but don't have a plan. So if they're entitled to protections under the act, they're also entitled to an MDR before they're excluded. It doesn't come up very often, but you should be aware of it. So when my client says, but my client had, or a lawyer says my client had a disability, years ago, you can't discriminate against them. So just keep that in mind. But here's the big difference under 504 compared to the IDEA. When you do exclude a student under 504 or on a 504 after an MDR, So, the student is on a 504, they engage in some sort of conduct, you go through your disciplinary processes, you expel the student, you do an MDR, you determine it's not a manifestation of their disability, and the kid is out. If they're on a 504, the services stop. They are not entitled to those day 11 services like an IEP. So under 504, there's no requirement to continue that education during the period of removal. And that's a pretty significant difference. Now, the exception to that, of course, because again, it's an anti-discrimination statute, if you typically provide education to your excluded students in general. So if you, always go back to that fundamental concept that this is an anti-discrimination statute. And if you routinely allow students who are expelled or suspended to participate in an ISS or alternative programming, or you shift them to online, whatever you do for your other students, you need to do for your student on a 504. Whatever options are available, you need to have those same options available for your 504 students too. Now, when you have your MDR, who has to be at the meeting? It's the same requirement as we talked about with the evaluation. So it's just people who are knowledgeable about the student and the disabling condition. It's not all the people who are required to be there under the IDEA. So you don't need the gen ed teacher, the special ed teacher, the district representative, someone to interpret the data, all those properly constituted IEP team members. That's not required. You just need, people who are knowledgeable about the student and the disabling condition. And that's who has to be at the MDR to make that determination. All right, does failure to recognize harassment violate section 504? So the answer to that is yes. So here's a flow chart. We were told back as early as 2000 by the Department of Education that disability harassment, which includes discrimination or harassment of a student based on their disability, can interfere with a student's receipt of FAPE. So if a child is bullied and they're not accessing your program, right? If they're bullied and so they're staying home, that's a situation where a student is being denied access to your federally funded program because of their disability. So OCR issued a series of Dear Colleague letters on this one. There was one in 2000 and another one in 2010. And they're very sweeping and extensive and, make it very clear that you need to address the bullying and harassment and then take steps to remedy that conduct. So this slide shows a flowchart of what your response should look like when you've got disability harassment. You can't always control what students do. I mean, we know that you teach them the golden rule, you tell them to be kind to each other, but you can't really control whether or not they are. But what you can control is your reaction to that behavior as a district. So ultimately, when these situations end up with liability to a district, it's when they're being litigated, it's because you've got a student who's being denied access to their education because of the bullying, and they say you didn't do anything about it, or worse, in the extreme cases, you're looking at how to pick up the pieces after a student suicide. And those are horrible situations, and no one wants to be in that situation. But you certainly don't want to also have to be able to, have to defend whether or not your reaction was appropriate when you're aware of bullying if you didn't do anything about it. Those are the ugly cases, and they end up with liability in addition to the tragedy. We see these cases in the headlines. There was the New Jersey case, I think, that maybe just recently, about a student suicide, and the facts were bad. I mean, they were just really bad facts about the amount of information that was given to the school district and what happened in that case. And it was just a tragedy. So you don't want to be in that case, and you don't want to be in that situation in the first place, obviously, because we don't want anything like that to happen to our students. We don't want those tragedies, but you also need to document what you're doing when you are made aware of bullying or harassment on the basis of disability, or in any situation, not necessarily just on the basis of disability. But when you can show that you responded appropriately when you were put on notice of that bullying or harassment, that's what you're going to need to be able to do if you find yourself in that situation. So follow your policy. So if you're put on notice of any bullying or harassment on the basis of disability, or any harassment on the basis of any protected class, respond immediately. Bring the parents in, find out what the problem is, conduct an investigation, look at your policy to see who the appropriate administrator is. You probably have a policy for that. It might be your civil rights compliance officer. It might be the high school principal. It might say a designee of the superintendent. You probably have multiple policies. Most districts have multiple policies with different procedures, depending on whether it's disability-based or other types of protected classes, or bullying and harassment that's not based on a protected class. Title IX, of course, if it's sexual harassment, there's a very, very regimented policy procedure that has to be followed. But whatever board policy that it is that applies to the complaint, there's going to be an investigation. And it might be simple. It might be interviewing the student. It might be really involved, like if you're under Title IX and you've got to follow all those steps. But whatever the facts are, you're gonna do an investigation, and then you need to document that investigation. That's going to be your evidence that you responded appropriately. And then the middle box on the bottom line: stop, prevent, and eliminate the harassment. That's what you do after the investigation. If you determine that bullying or harassment took place, you need to take action to stop it and prevent it from happening again and eliminate the effects. And then the last step for students with disabilities is, and this would be, same with a student on a 504 or an IEP, they might be entitled to comp ed if they've been denied access to your education program. It might be that they need social skills training. It might be that they need additional supports and help. They might need counseling. But maybe part of the reason they were bullied is because they don't understand personal space. They stood close to people, or they were touching them, and then students were making fun of them. So they may need other supports. It may be because of hygiene. I mean, there may be things that the student needs help with, to address that. And that's part of the prevention piece going forward. So be thinking about that when you have those situations. All right. And my 10th question is, what should we do to avoid, or what should we avoid to lessen the risk of these kinds of complaints? So we've talked a lot about what we can do, but I've got a list on this slide of things that you should not do, because, not providing procedural safeguards, these are the things you don't want to do. Putting an obligation on a parent to trigger the evaluation, especially remember that dear colleague letter about ADHD, that I read part of it to you about the district staff being the eyes and ears of the district. You have that child find obligation. So you have the burden of looking for children who need special education and related aids and services. That's, your child find obligation. You need parent consent. And if they refuse consent, you've met your child find obligation. You suspected a disability, you asked for consent to evaluate, they said no. That cuts off their rights under 504, but you have to be proactive. You can't just wait for parents to act. Not training staff, not conducting those staff in services. Staff also need to know what's at stake. What they're seeing may be putting the district on notice for child find purposes, even if it's not communicated up the chain of command and it doesn't get to the student services director. Training on 504 is really important, and knowing who your 504 compliance officer. Something that's not on the slide, not using the phrase, "tell me more." You want to actively listen when you're communicating with parents. Tell me what you think. Tell me why this student needs this. What is this going to do for him or her? Engage in that interactive process and gather as much information as you possibly can. And then, if they're asking for, we get the example all the time of people asking for the emotional support pet. I think I had a district that a student wanted an emotional support. I think it was not an iguana, some kind of lizard. I don't know, something like that. And we encouraged the district to talk about why they felt they needed that support animal, and then discuss other way, as a result of anxiety, that it mitigated or reduced the child's anxiety. And then we engaged in the interactive discussion of other things that could also be done to mitigate the child's anxiety in order to work toward an accommodation of the underlying concern, without necessarily saying, yes, you can carry your, I think it was a dragon lizard or something. One thing we also see is sometimes on a 504 plan, you'll see an accommodation that the child is responsible for. And we would caution against that too. So if you've got an accommodation that is the student's sole responsibility, and you don't have a district employee, checking up on it, if the student doesn't do it, then you're out of compliance with the 504 plan that you wrote. So we caution against that. Now, that doesn't mean you can't work toward independence, but someone needs to be overseeing that accommodation. And if you've got, and I had a case recently on this, I had a district call me about a situation where a student was refusing to do the accommodations on the 504. Okay, what do you do in that situation? You reconvene the team. Because if the student is refusing to seek the accommodation that's on their plan, you need to redetermine whether that accommodation should be on there. If they're not accessing the accommodation, come up with another way to provide an accommodation that they can access or that they're willing to access. So those are just some things to do to be proactive. I am going to just super quickly talk about the new HHS proposed rules that are out. I don't know if you all have heard anything about this. The Department of Education is supposed to be coming out with proposed 504 rules. I don't know what the timeline looks like, but the Department of Health and Human Services in September put out their new proposed 504 rules. Just keep in mind, these do not apply to schools. These don't govern how how schools deal with 504. This is a different federal agency and it applies to programs funded under Health and Human Services, so medical programming. But I did want to just really quickly go through a couple of the changes in there because it might give us a preview of what we're going to see when the Department of Education comes out with their own new 504 regulations. So these are not law, and I'm just going to cover these really quickly. These aren't law for HHS either. These are in that proposed phase that we talked about where they're open for public comment. But a couple things that we can see, the proposed rules begin with a purpose provision. And it indicates that the definition of disability should be construed broadly in favor of expansive coverage. That's not a new concept, but that's certainly how it's been interpreted, but it's right there in the rules. And so it's reasonable to expect that similar theme is probably going to be in the Department of Education's anticipated regulations when those come out too. The proposed rules clarify that they're going to apply to areas not explicitly addressed by the existing regulations, mostly because the existing regulations are, 40 years old. And so the kinds of situations that may come up didn't exist 40 years ago. So like, kiosk accessibility and, they're talking about things like telehealth and those types of things, but we also have similar advances in technology and education. So just be aware that that's going to be expressly covered. And then, I'm sorry, I'm not on the right slide anymore. Here we go. Okay. And then language that tracks the ADA. They have language that tracks the ADA, including the definition of disability. It includes long COVID in the definition of disability. So that's obviously something new. It has a retaliation provision, prohibition against discrimination, direct threat definitions, service animals. So these are all things that we think are going to be covered in the new regulations. All the updated terminology is going to be in there. Take out the word handicapped and talk about disabilities. So the terminology is updated. The proposed rules also address developments in case law. So the regulations proposed by the Department of Education might do that too. Maybe a regulation about the availability of remedies, that there's, no damages for emotional distress, or about the interplay of remedies between the IDEA and 504. So maybe that'll be addressed in the regulations. And the proposed regulations also address preschool education and daycare programs. So, they'll have an effect on preschool and possibly aftercare programs that are run by a school district. So we'll see what those look like when they come. All right, so my next section is what would you do? And there's a scenario. Kim, do you want to go through questions in the chat first? Is there anything in there?
Sure, we can do that.
Okay.
One of them, like when you were talking about the students with seizures, the question was asked, should a student who has a seizure or seizure disorder, should they have a 504, or is that seizure plan and the medical plan with the school nurse enough?
That's not a question, unfortunately, that I can answer. I think that it depends on the student's situation and what it looks like. You are required though now to have that seizure action plan. Is that what you're referring to? The new
yeah, the one that took effect October 3rd, I think is what that was.
Yeah, it did. That's exactly right. October 3rd, the new requirement for the seizure action plan. That can certainly be incorporated into a 504 or can be a standalone. It's a local decision.
Okay. And that's good information to know here as well. I hadn't heard that it could be tied into that 504 as well. So that is good to know.
Mhm.
Um, and then someone else had asked, could you give an example of what kind of special ed services might be provided after student is removed due to that manifestation determination review? And I do believe you touched on that a little bit, whether it be some kind of compensatory services or whatnot.
Right. So are you asking about day 11 services though, that are not required here? Or are you talking about when you typically do offer services to other students? I guess I'm not sure what the question is.
I think the question was in reference, like if you would remove a student on an IEP, then you're, obligated for that interim alternate educational setting. Does
Right.
it have that same type of um, requirement for a student with a 504?
No, it doesn't. So under 504, if you remove a student because it is not a manifestation, you determine it's not a manifestation of their disability, and so you're going to expel the student, you do not have to provide 504 services, only if they're on an IEP.
And then another one that was in the chat is, do you have a recommendation of how to handle an accommodation that could be a hazard or a medical concern to another student or staff member? And this is one I think we see a lot. You probably do too. So if a student qualifies to have a service or support animal, but there's another person who has severe allergies to that type of an animal,
Yeah.
how would you handle that?
Those are hard situations. So, we've got balancing rights here. You've got the right of the student to have their support animal if that's the accommodation that you decide is appropriate for that student, and you've got the rights of the other student to not be exposed to an allergen that's going to cause them, to have problems at school. So, what you can do in that situation is try to separate them. I mean, that's probably the best thing. Try to keep, people who have those competing interests in separate spaces, but you just have to look at it and see what the needs are and the resources that you have to try to accommodate both. Those are hard. Those are going to be fact specific, where you've got to, think about all the considerations and talk to legal counsel.
Yeah, and that's what I know from like our agency. That's what, if anybody asks us questions, we tell them to contact their their legal counsel to work through that because it is so individually student specific.
Yeah, and that's the key. That's the reason. It's not because we're trying to be evasive. It's because there's going to be a million details and considerations that have to be taken into account to try to figure out what to do in that situation.
And then I did have a question that came in a private text to me, and I just want to make sure I was correct on this one. So if a student is to go on a field trip who might be diabetic and it's, they're on a 504,
Mhm.
do they have to send a nurse on that trip? And my response was that it would really depend on whatever that medical plan is for the student. So if they don't always have a nurse, you wouldn't necessarily be obligated to send a nurse that day. However, if there are those situations, it would just be aligned to whatever that student's plan
Right.
is.
So I think that's exactly right. And I think what you do is you go back to the overarching principle is that we need to provide equal access to the program. So if they need that nurse to be able to be safe on that trip, the nurse goes. If they don't need that nurse to be safe on that trip, you don't need to send the nurse. So it's going to depend on the individual situation.
And that is all the questions that we have right now.
Okay, well, perfect. All right. Well, then the next thing we're going to do is I'm going to read a scenario. Bear with me. I'm going to take a little drink here so I can make sure I can read it without starting my coughing fits again. All right, so I've got a scenario about 3 students, and I'm gonna read through the whole scenario, and then I'm gonna ask you some specific questions about each one, and you all can think about what you would do in these situations. So these are what would you do scenario. These are aggravating allergies. A new family has moved into your school district, and only 2 weeks later, you have 3 voicemails from mom, one regarding each of her 3 children. Although the children's enrollment paperwork doesn't say anything about any of the children having a disability, mom is now requesting various accommodations for each child. So first we have Fishy Philip, a 1st grader. And apparently Fishy Philip has a serious seafood allergy that is triggered not only by the ingestion of seafood, but also by skin exposure. In mom's voicemail, she shares with you that in the past, this allergy has created anaphylaxis, a severe whole body allergic reaction to a chemical that has become an allergen. Symptoms of anaphylaxis can include closed airways, hives, nausea, vomiting, heart palpitations, and even unconsciousness. Philip's mom is requesting a health care plan to ensure that his lunchroom will be completely seafood free and that his lunch table will be thoroughly wiped down before he uses it, and that he will have access to his EpiPen at all times at school. Other classmates at school have food allergies, so some of these requests, like wiping down tables and carrying EpiPens, are not new to you or your school staff. Therefore, you suspect that your school staff will not see a need for a health plan for Philip. After her voicemail to you about Philip, Mom wrote you an email complaining that for the second Fish Stick Friday in a row, another student approached Philip's lunch table waving the fish stick in his face. She writes that Philip is now very anxious about going to lunch because of the incident. Mom indicated that she had great difficulty getting him out the door to go to school today, and Philip is telling his mom that he won't come to school tomorrow. Then she has her daughter wheezing Wendy, who is a brilliant fourth grader with asthma. And in Mom's second voicemail, she tells you that Wendy's asthma seems to be exacerbated by strong smells, such as cleaning supplies or the new Katy Perry perfume that every fourth grade girl seems to drench herself in every morning. The other day, she had an asthma attack before a big test, and her mom had to be called to administer an inhaler to her so she could go back to class. Your school nurse has shared with you that she tried to explain to Mom that she could fill out a form so the inhaler could come to school with Wendy, but Mom is insisting that Wendy have a 504 plan instead. Wendy missed a substantial amount of school last year due to asthma-related issues, but typically the inhaler is all she needs. Your school nurse thinks a healthcare plan and administration of medication form would be sufficient to address this issue. And then we have her oldest child, gluten-free Gloria. She's a seventh grader on a gluten-free diet due to her problems concentrating while in school. Mom, in her quest to help her daughter, found the diet on the internet. Mom heard from Gloria's teachers that she's had trouble organizing tasks and activities, completing assignments, paying attention in class, but has noticed how after going gluten-free, her grades and focus seem to have improved. However, the other day, Gloria apparently ate a birthday treat that a classmate passed around and then scored very poorly on her tests for the rest of the day. Even worse than she had been doing at her old school, where she wasn't exactly a stellar student. Mom wants a guarantee that the school will maintain Gloria's gluten-free diet at school and wants to be accommodated through the National School Lunch Program. Gloria's teacher tells you that she offers alternative allergen-free treats to every student, but Gloria turned it down and knowingly went for that cookie. All right, so those are our three kids. So let's start with Fishy Philip. So Philip, is he likely disabled? So your choices are Philip is disabled, and I would develop a healthcare plan. Philip is disabled and I would develop a 504 plan, or Philip is not disabled. So again, this is easier in person where we can, kind of do a show of hands, but these are the situations with Philip. So remember, he's got that seafood allergy that could lead to anaphylaxis. Mom wants a healthcare plan. And we've also got the kid waving the fish stick in Philip's face. I'm sorry, I am not advancing the slides properly. I should have put those up while I was reading them. So I'm just going to flip through them again one more time so we know we're on the right page. So wheezing Wendy, asthma with strong smells, Mom comes in with the inhaler, and the nurse says a healthcare plan. And then we've got Gloria, who's on the gluten-free diet that Mom found online to help her concentrate. And Mom wants the school to guarantee that that diet is adhered to at school. And the teacher says that Gloria went for that cookie on purpose. Okay, so we're going to figure out whether they're suspected disabled, what their disability is, and what the next steps are. Here we go. Okay, so is Philip likely disabled? The answer is going to be B. Philip is disabled. So his seafood allergy is severe. I mean, we're talking about heart palpitations and anaphylaxis. It renders him substantially limited in the major life activity of breathing, eating. He's going to qualify. I think that's pretty clear. You could maybe address this under a healthcare plan, but if you do, it might not check all the compliance boxes. So I would do a 504 go through the whole 504 process in this case. And if you have OSBA policies in your district, your policy probably says that you're going to address food allergies on a 504 plan. So look at your policies as well. But, you should evaluate, you should convene a group of people who are knowledgeable about the student and the data and the placement options, and then write a plan that's appropriate for Philip. So what is this plan going to look like? So is it an appropriate accommodation to create a seafood-free lunchroom? Is it an appropriate accommodation to have Philip eat alone? Or is neither one of these appropriate? So let's think about this. So let's go back. If the circumstances where the severity of the allergy requires you, there are circumstances where you're required to have an allergen-free environment. So I would want to have the best medical advice I could get. Ask for a release, talk to the doctor if they'll let you talk to the doctor. There is case law out there about a peanut allergy, where the doctor said, this is the worst peanut allergy I've ever seen in my career. It's airborne. If it's in the building, it can go through the HVAC system, and ultimately the child could die. This was a really serious situation with this case, and that's what the doctor said. And so the district adopted a peanut-free building policy. And that decision was challenged by another person in the district who thought it was unreasonable to have a peanut-free building. That person thought their child's rights to eat peanut butter were more important than the other child's rights to go to school and live through the experience. And the court said, no, this is reasonable. The medical evidence established that the child's allergy was severe and life-threatening. We talked a few minutes ago about that balancing of rights. It's something we lawyers grapple with in a lot of contexts. But in this case, come on. We're talking about the right to eat peanut butter versus the right to live through the school day. That's a pretty crazy situation, but I'm sure you've encountered it. I know we have. I know we have a lot of clients who say that parents don't want to comply with the other person's, allergy restrictions, and why should my child not get to do this just because of the other child's situation? But when you're talking about something like this, it's really kind of a no-brainer. So, it's going to be appropriate here as an accommodation when you've got a severe and life-threatening allergy to create an environment for that child that is free of the known allergen. So you're certainly going to want to have the best medical advice you can get. But in this case, from what you're being told, Philip's situation is pretty severe. He needs an EpiPen. He can't breathe. So we're also told that the USDA guidance on food allergies, that you're required to accommodate this. So it's not only a law under 504, this is also the law under the USDA, food, USDA guidance for foods. So what about the option of having Philip eat alone? Hopefully none of you chose that, because that's not his LRE. So having him eat by himself is gonna violate the LRE. Also, the USDA lunch program guidance also includes an LRE requirement. So again, that's something that comes from two different laws. So on the 504, what's it going to look like? Let's see, what there should be procedures in place. Who's going to be responsible for wiping down the tables? That's something that you can put in the 504 plan. Training of staff on what to do in response to an exposure. How you're going to handle notification if there has been an exposure. That's what the 504 plan can look like to accommodate this. And then what about offering an alternative food plan or food option on Fridays when we have fish stick Fridays? Let's say you get to a point where you don't have to have a seafood-free environment. The medical advice says that's not necessary as long as he's not within, there's nobody eating fish at his table. So let's say we've got a seafood-free table, but we're still going to have fish stick Fridays based on the medical advice. Should you make him pack his lunch on Fish Friday? So the answer to that is no as well. You are required under the USDA lunch programs to accommodate him and to make substitutions if you have medical evidence of an allergy that needs to be accommodated. Now, if it's not supported by a medical statement, you still have the option to make a food substitution, but not the obligation. So as far as what you serve in your cafeteria, you only have to serve the alternate option after receipt of medical evidence. So the parent is obligated to provide that. And just keep in mind, though, that if you do that, it doesn't have to be the child's first choice. I was helping a district recently with a student who had, I want to say it was a soy allergy. I don't know, it might have been gluten. it was a legitimate allergy. There was no issue about that. And we had medical evidence. And so the district was going to provide alternate meals in the cafeteria anytime their food had whatever the allergen was in it. And the parent was really resistant because some of the alternate foods that were being offered were not things that their child liked. And you know, that's not a requirement. Just like you may serve hot dogs and kids don't like hot dogs, whether they're allergic to them or not, their option is to send a different lunch. So you do have to provide an alternate meal with the receipt of that medical evidence, but it doesn't have to be, you know, the child's choice of what you're going to serve. What other steps might be taken for Philip? How about the possible eligibility under the IDEA because of school-related anxiety? He doesn't want to go to school anymore because of the things that are going on. Is he being harassed and bullied? I mean, somebody waved a fish stick in his face. That's not very nice. And you know, it might be disability-based harassment here because it's on the basis of his disability. We're talking about making fun of the kid because he's allergic to fish. You know, should you conduct an investigation to see if discipline is necessary? You know, as I probably told you earlier, anytime you have a list of multiple choices with all of the above at the bottom, it's probably all of the above. In this case, I would definitely suggest that you're looking at all of these things to be done to handle this situation with fishy Philip. All right, let's move on to Wendy. We're running out of time, so I'm going to go fast. Okay, so again, this is easier. We can do a little show of hands, but how many of you think Wendy is not disabled because she's not exhibiting any adverse impact on her education? Remember, she's the brilliant student that's not having any trouble at school. Well, it sounds like she is substantially limited in the major life activity of breathing. She's got some chemical insensitivity to, you know, the cleaning supplies, the perfume. So what kinds of things can you do? You could have mom complete an inhaler authorization form. You could request a 504 evaluation. You could request permission to consult with her healthcare provider, or you could do all of the above. And I already told you the answer because it's going to be all of the above. So, you know, recognize that having a completed inhaler authorization form on file with the school might not sufficiently address Wendy's issues. You know, it's going to address the practical issue so that mom doesn't have to run to school every time Wendy needs it. From a child find perspective, though, it won't eliminate the plan or the need for evaluation and possible development of a 504. So I don't think that's enough, but you could certainly do that. But like Philip, you know, convene the meeting, provide the parent a copy of the 504 procedural safeguards, request permission to conduct an evaluation of Wendy, and, you know, see what these chemical sensitivity issues may be coming from. You know, you're going to need information again from medical providers if they'll let you have it in order to determine, you know, what the existence, nature, and extent of that disability might be, and identify any kind of recommendations that they may have in terms of what she can tolerate and what she can't. So there might be consideration of, you know, what the triggers are for her allergies. If she has multiple chemical sensitivities, medical information is going to be really important to determine, you know, what kind of environmental irritants there are that might be causing the problem, you know, how she's exposed, what kinds of exposure, how long exposure has to be to cause her problems, you know, what are the reactions, what happens when Wendy is exposed. So you're going to want to evaluate for those types of things. And then the evaluation will provide, you know, more information on what accommodations are going to be appropriate. So it's going to be important to consult with Wendy's healthcare provider so that the information gathered directly isn't filtered through mom. This isn't meant to be, you know, critical of parents, but sometimes parents perceive health risks to be more severe than they are because they're talking about their own child. They're obviously a little more, you know, emotionally connected. So if you can talk directly to the physician, that's always going to be the best way to go if you can. But sometimes, unfortunately, we don't always get that consent. But that is what I would do there. All right, so back to Gloria. She really wanted that cookie. I kind of feel bad for her. So do we suspect that she is disabled? And if so, are we going to do a 504 or an IDEA evaluation? Or do we think that she is not disabled at all? You know, she doesn't appear to have a food allergy or celiac, right? This is some diet she's undertaking because the internet said it would help her concentrate. So I'm not sure we're really in a situation of a food allergy like we are with the other two kids. But when you think about the facts here, what are her teachers describing? The teachers have been observing, characteristics including trouble staying organized, completing assignments, paying attention, focusing. That's what the teachers are reporting that they've seen. And so this sounds a lot like ADHD. And, when you think about that dear colleague letter that says that we're the eyes and the ears of the district. And when you're seeing those things, we need to, this is an underserved population. So we need to be looking at this. Now, mom did tell you that the gluten-free diet is voluntary. So I don't think that's the disabling condition. I don't think that's the situation, but I want to know more about this ADHD. So I'd be wanting to think about that. So you need to evaluate, and how you evaluate is your decision, but you need to evaluate either under 504 or under the IDEA. And then what about a food substitution plan? Whatever plan is ultimately developed for Gloria, would you include a food substitution or modification plan in the cafeteria? Remember, mom is demanding that this diet be strictly enforced by the school district, and that you make sure she never has access to gluten, or she never, gets gluten while she's at school. Do you have to include that food substitution plan? Well, like I said before, if it is a medical, if you have medical documentation that there is an allergy that needs to be accommodated, you are required to offer that food substitution plan. But here we just have mom saying, I don't want her to have gluten because of the concentration issue. It's not an allergy. So it is optional. You could certainly go either way. It's not necessarily required, but that doesn't mean that you can't do it if you want to. And my guess is that, at least in terms of food options in the cafeteria, this is probably not your only student who is saying, or who is in need of an option on of gluten-free food. So it might be something that's pretty easy to accommodate, even if you don't have to. So that is it. That brings me to the end of the presentation. Do we have any more questions in the chat?
The only question that popped up in the chat was the difference of would you need to administer a 504 plan or a healthcare plan? I think you addressed that a little bit.
Yeah, so I think that's, again, it's just going to depend on the circumstances for the child and what their needs are.